I mean, my goal is to treat people similarly, whether they're rich or poor. All right, Zaon Collins, 20 CR 041639.
Morning, Richard Schonfeld and David Chesnoff on behalf of Mr. Collins, who is present.
All right, Dave, this is your motion.
Judge, as you've seen from the briefs, not only is this a Las Vegas Justice Court approved method of monitoring somebody when they're released, and as a condition of the release, it's something that the defendant and defense counsel agreed to, they would abide to as a condition of his release. He failed not just once, but twice. Judge, in addition, as you saw from the briefs, it's approved by the FDA as a method in detecting drugs and is generally accepted in the scientific community. So there's no surprise that their only angle at this, their best angle, is to find somebody who's going to come in and say, or submit a report like they did, says, oh, the drug patch is no good. It's flawed on multiple fronts, as you can see from the SCRAM expert toxicologist that I submitted to you. Their expert cites, oh, this could be environmental factors, it could be something he ingested, some food, some medication, problem with, how the meth got on there. What that person is either trying to intentionally mislead or simply doesn't understand is this is monitored by sweat, Judge. He's testing positive not just for meth, but the metabolite that's produced in your body. So this whole argument of, oh, it's flawed because of, somehow it got on there or he ingested something, unless he's ingesting meth, well, it's the metabolite that he is sweating out that is testing on that patch, not just once, but twice. So any type of contamination or this is no good because environmental factors or somehow meth got on that patch goes right out the window when you're actually testing for the metabolite as well. This individual, no question, tested twice for the metabolite in addition to meth. I'd ask you remand him and increase his bail.
So how long has Mr. Collins been on the patch?
Since the beginning, Judge.
I don't know when the beginning was. That would be before my time.
This is January of 2021.
And is this the only positive test in a year and a half?
2 positive tests, Your Honor.
Right, but is this the only event that we're discussing?
Yes, ma'am.
Okay. All right, defense.
Thank you, Your Honor.
Wait, you wanted David here and he's not going to talk?
I can talk if you want, Your Honor, but I'll leave it to Mr. Schonfeld.
Your Honor, we provided not just a report from Dr. Buffington, but also his curriculum vitae. He is a foremost expert in this area.
I'd really rather talk about your client instead.
Okay. So, Your Honor, obviously our client vehemently denies having used methamphetamine, having been on pretrial supervision for over 16 months with no positive tests up until this point in time. You have 2 consecutive patches, which is consistent with it being a false positive. On, I believe it was Thursday or Friday, Scram submitted his test after that, which was negative. We provided a polygraph examination to the court where no deception indicated. And the questions were so broad: have you ever used methamphetamine? Has anyone ever provided you with methamphetamine? At the point in time when these tests were collected, he was still on house arrest. Both of his parents were present in court. They'd never seen him use methamphetamine, nor did he appear to be impaired at any point in time. So the SCRAM test is really supposed to be used as a presumptive tool, just like an ODB field test when police officers test drugs. But when it comes to actually somebody's liberty interests, there should be a scientifically reliable test, such as a blood test. Given that there was a 23-day gap in one of these tests and more than a 30-day gap in these tests being reported, we didn't have the ability to take a blood test. In terms of what Mr. Collins is doing now, Your Honor had taken him off house arrest approximately 3 weeks ago. 2 positive things to report. One, he enrolled in CSN because the court wanted to see him in school. However, because summer classes had already started and were full, he can't actually physically take classes until the end of August. But in the meantime, he has also been accepted on a full scholarship to the Salt Lake Community College, which is the equivalent of a D1 school in terms of basketball, but a full athletic scholarship. If the court were to permit him to relocate temporarily as a student to Utah, he would start August 23rd, 2022. He would also be accepted into their academics, both academic and athletic programs. I can provide the information to the court. That would be our request, but as a backup, he also has enrolled in Community College of Southern Nevada so that he will be attending classes in person.
How many hours?
6 units, Your Honor, starting August 29th.
Why not full-time?
I believe that it was a scheduling issue, Your Honor.
With the school.
This is at CSN, but the school in Utah is full-time school, Your Honor, and I do have the letters.
I'm not going to agree to allow him to attend school out of state at this time.
So we'll make arrangements, Your Honor.
But Mr. Collins, I mean, you can go to college full-time starting next month. Why would you only do 6 hours?
That's just the way that the school put it. We can't talk to them and get arranged with them.
I mean, you're just, I don't know what's going to happen with your case, but you should be moving on with, or go to UNLV full-time.
Yeah.
Well, that's a problem.
Is that-
That's an issue, Your Honor.
Not a possibility.
We would hope so, but at the time of the event, he was supposed to be a enrolled scholarship student, Division I ball player, and they were told they didn't want to come there.
Okay. All right, so you need to be in school full-time starting next month. I'm concerned about these 2 tests, but he's also been on it for 1.5 years with no issues. I keep asking this question and nobody knows the answer. When is the Supreme Court going to make their
That's why he's
decision?
gonna kill somebody else. He killed my husband. Let him out, let him kill everybody.
Your Honor, fully briefed at the Nevada Supreme Court. The petition was filed, the Supreme Court ordered an answer both in substance and procedure. The state filed their answer, we filed a reply, so we're just waiting for the Supreme Court to take action. Can we perhaps file something in reference to the Utah school? It's just such a...
Yeah.
Well, Your Honor, we will make arrangements for him to be enrolled full-time in college here, and we understand why he can't leave. That's all that happens with the case, obviously, and we'll revisit it at an appropriate time.
I'm just going to be honest. I understand the state's concern with these positive tests, but I'm not sure how if I remanded him to custody and increased the bail and he posted that and got out, what have we accomplished? You know what I mean? Because that was your request to remand him and increase the bail.
Yes, and I would think it's very important when the court issues an order that it actually has teeth. And
I agree. But it's
that-
not helpful when we don't find out for a month that there were these alleged positive test results.
Well, Judge, again, this is a justice court approved method, and they're reporting it in a justice court approved method fashion.
And Your Honor, can I speak to that? There's been a lot of justice court methods that have over the years been employed, depending on also who the court we were in front of, and they haven't always been right in terms of their application. And here we have drug usage of a drug that's completely foreign. It's not as though he was arrested as a result of having meth. He has no indicia of being a meth user. And the expert, there is nobody in the United States who knows more about this than Dr. Buffington. He testifies in federal and state courts everywhere. We'd ask you, Your Honor, not to remand him, allow him to enroll full-time. We will personally make sure that that occurs. We will not talk about Utah unless it's an appropriate time when the case is over.
So this is what I'm slightly offended by, state. If it wasn't for the fact that this is a high-profile case, because I've got plenty of other cases where people are positive on the scram patch or monitor, and I'm getting no motions from the state regarding those. In fact, I have one that I put on calendar myself this week because the number of positive tests for alcohol is so offensive. it's like nearly every day. But am I hearing from the state on that? No motion, because this is just a regular person.
No, I have personally seen you revoke somebody.
Absolutely, but I'm not getting motions from the state on these people because they're just regular people.
Judge, I can tell you that I have personally seen you on my cases revoke people
Right,
that have been out for that.
right.
And it hasn't even taken a motion. It's simply you tested positive, bye-bye.
My question is, where's the state's motions in those cases? The one I put on calendar this week for Thursday. The guy has tested positive for alcohol probably 100 times, but I got nothing from the state. I'm the one who put it on calendar.
It doesn't even take a motion half the time because the court is aware of it and puts it on, or the court, the next time it comes up in calendar, I see the issue in the file. So I would say it's not. The court is either putting it on calendar, or when we come in to court on the status check, it's in the file, and the court is doing it without even a motion.
You're missing my point. Why is the state not bringing up all these motions on all these screening tests that are positive for drugs or alcohol? Why is it only on Mr. Collins?
No, I think it's the other way around. If this case if I would have had that in the file, and if this was my case, I would have brought it to the court's attention, and I guarantee you, as I've seen you before, you address it at a status check or something. And it doesn't even take a motion to put forward, Judge. In this case, yes, given we were preemptively before the status check putting it on, in part because it's up in the Supreme Court and it's just lingering out there. But if this would have been a regular status check date that on a particular case or a not even a status check, a written entry of plea or a trial date, yes, it would have been in the file and we would have brought it up then. That's why it's taken a motion in this particular case, because how many cases in the Supreme Court do we have in this department? Not many.
Only a couple.
What's that?
Only a couple.
Thank you. Well, yes, Judge, that's why it took a motion to put this on.
I mean, my goal is to treat people similarly, whether they're rich or poor, whether that is a burden to them or not. So I don't want to treat them better because they're rich, and I don't want to treat them worse because they're rich. I want to treat everybody the same.
And
For the record, Mr. Collins is
She was speaking to me.
Mr. Schonfeld and I are doing this pro bono. His family does not. The only thing is the notoriety, Your Honor. You hit it on the head. It's like in the beginning of the case when they reported he had a gun in his car when he didn't. Everything was exaggerated because of the fact that it was a young man who had some notoriety as a result of having led the local high school to state championships on multiple occasions.
Well, and I'm not losing sight of the fact that somebody died in this case, and that's very serious. And whatever Mr. Collins is to be charged with, I guess, remains to be determined. What charges he's going to be left with to fight.
Hey, Judge, I do not think there's any special treatment in this case. If anything, I think if he walks out that door with any type of repercussions, I think it's the other way around. I absolutely believe if this was on for a status check and you said you're a normal person walking in the door, let's say a public defender client, if I would have brought forward to you today and I would have had him in the file, that, hey, not just one time, Judge, but 2 times he's testing positive, I find it hard to believe that he would just be walking out of here with no repercussions.
Anything else?
Yeah, Your Honor. I don't think you need to do it, but if we're going to take the extreme position, after listening to you articulate the reason why you find it offensive, then at a minimum, there has to be an evidentiary hearing because I'm not going to accept the DA on science. This is a due process issue here, Your Honor. And also, what is really accomplished by having somebody with a questionable test get violated, Your Honor, when the reality is the concern should be whether or not he's using drugs, which is not the case. We have another test that occurred. If you're using meth, you don't stop.
So I'm going to require Mr. Collins to submit to random drug testing. All right? Blood testing. All right?
Yes.
So when he's directed to submit to a blood test, he has 12 hours to do it. All right?
Understood.
And it'll be a blood test, and it'll be at his expense. When is our next status check?
Number 15, that
All right, so Mr. Collins, full-time college.
Your Honor, how will we get notice of the random tests?
How would you like to get notice? Do you want it to be to you or directly to him?
If you send it to me, I have no trouble at all getting a hold of Mr. Collins.
All right. So, Mr. Collins, I don't know if you've used or not, okay? But it is a condition of your release to be drug-free of all substances, alcohol, and any legal or illegal substances, all right? So, I expect that there will never be another positive one again, all right? I mean, I'm just procedurally concerned with what charges he's going to end up with. That's my concern. So, see you guys in September.
Thank you, Your Honor.
See you tomorrow.
Not again.
Thanks, sir.
All right.